Good afternoon and welcome to our autumn 2020. Okay, so for those of you who don't know me, my name is Martin Sloan. I'm one of the partners in the commercial services team at Barodies, and I'll be presenting this morning alongside Grant Campbell, another partner, and Rachel Lawson, who is an associate in our team. So the programme for this morning, or this afternoon, we will start with Grant giving a quick update on data reform in the UK. Grant will then hand back to me, and I'll talk a bit about international transfers. And then I will hand over to Grant and Rachel, who take through the rest of the session, talking about latest regulatory developments in terms of new guidance and codes of practice and ICO things you want to be aware of, a bit about the latest enforcement action, and then we'll do the usual horizon scanning at the end of what's coming down the track, and then move to questions. So I say, please, if you've got questions as we go, please pop them in the Q&A function, and we will pick them up at the end of the session. Okay, Grant, over to you for the latest on reform.
Thank you, Martin. Well, good afternoon, everyone. Yeah, I want to talk a little bit about data protection reform in the UK. And for those of you who joined us in June, you'll recall that Martin talked a bit at the time about a consultation exercise that had closed by the UK government and proposals for data protection reform. And Martin went through what we thought was coming down the track in a bit of detail. Well, in July, the government published the Data Protection and Digital Information Bill, the DPDI, and the stated aims of the legislation were to reduce burden and provide greater flexibility for compliance. The measures that were revealed in the bill, which is quite extensive, weren't really a surprise given what had come out of the consultation exercise, but there were a few things that are worth mentioning again, just so that people are aware of what the bill actually said. So one of its measures was to create a new recognised legitimate interest ground for processing. So unlike normal legitimate interest, this one would be almost like a whitelist. Be no need to do a legitimate interest assessment. I think the point out of the bill that I picked up is that the schedule at the back that contains the recognised legitimate interest, they're all very public interest focused and probably not that useful for private sector organisations, but there is scope for those to be extended, and they may be extended during the passage of the bill. There were provisions in the bill relating to data subject access requests, so new provisions that are particular provisions for vexatious data subject access requests. So this is extending the provisions beyond manifestly unfounded and excessive, which is what we have in the current legislation. And there were also provisions allowing the clock to be stopped. So if you went and responded to a DSAR by legitimately asking for further information in order to be able to respond, then the clock would be stopped. There were provisions relating to automated decision-making, so a relaxation of the current restrictions with safeguards. Mainly, the restrictions would then focus on special category data rather than data generally. On accountability, there were provisions softening the requirements for record keeping. So the ROPA that we currently have has been, I think, watered down. And also DPIAs now would be called high risk processing assessments, and by the very nature of the name, you can see that they are very much focused on high risk processing, although still encouragement to do DPIAs, particularly for those who currently do them. Changes to the PECA regulations, particularly around cookie rules, so an extended list of exceptions to the requirement for consent. And in relation to unsolicited direct marketing, as we expected, the soft opt-in rule, which is currently only available for commercial organisations, which seems to be a bit of a nonsense. The proposals there to extend soft opt-in to cover non-commercial organisations, including charities. Clarification of the UK rules on international transfers and cross-border data flows. And Martin's going to talk a bit more about international transfers generally. But the UK test for assessing other regimes was going to be whether the protection was not materially lower. And then finally, the last highlight, there's much more in the bill, but the last thing that I wanted to talk about was just briefly The bill does contain quite extensive changes to the ICO in terms of setting it up, I think, in a way that's probably consistent with more consistent with other regulators. So rather than having the Office of the Information Commissioner, we would have the Information Commission. But there were other rules in terms of, for example, codes of practice and the right for the Department of Digital Culture, Media and Sport to approve codes of practice that the ICO was issuing. So that bill was published in July. It went through its first reading. Its second reading was scheduled for early September, which you will remember was around the time of the Queen's death. But the second reading didn't happen, and the bill has been paused ever since in the parliamentary process. So the bill is paused at first reading stage, and then we had the Conservative Party conference in early October, and you'll recall this is around the time. So the consultation and the bill was all part of Boris Johnson government plan for data protection reform. You will remember then that we had a regime change. We had Liz Truss as Prime Minister, and Michelle Donnellan, who is the Secretary for Digital Culture, Media and Sport, stood up at the Conservative Party conference and delivered a little bit of a bombshell, which is on the screen. Today, I'm announcing we will be replacing GDPR with our own business and consumer-friendly data protection system. So I think that took everyone by surprise. And there may be a bit of hyperbole in the language, but it does mean that actually the actual plans, the government's plans for the bill, which hasn't been pulled, are somewhat unclear. And of course, since Michelle Donnellan stood up at the Conservative Party conference, we've had a further regime change. So we have a new Prime Minister. And the question therefore is, what is the status of that bill? Is it going to be revived? Is it going to continue as it is? That seems very unlikely. But is it going to then be heavily amended, or is the bill going to be pulled? We don't know is the short and simple answer. There has been some utterances from various officials within the Department of Digital Culture, Media and Sport that have suggested that there is a consultation ongoing. It doesn't look like it is a formal consultation in the way that the consultation exercise was run before the DPDI was actually published, but there seem to be consultations with business going on at the moment as to what the government will do. What we have heard is that maintaining adequacy is going to be the cornerstone of what the government does. So it's not clear whether or not actually the GDPR is going to be replaced, as was announced at the Conservative Party conference, or what we're going to have is more extensive revisions, perhaps through further revisals to the DPDI. So it's very much a watch this space, and clearly what we're seeing is, ongoing uncertainty for clients in terms of what actually is likely to happen, and how far the UK regime is going to diverge with EU GDPR. And for those organisations that are regulated both by UK data protection law and EU data protection law, then clearly the greater the divergence creates greater issues in terms of having to manage compliance under both. But the message at the moment is watch this space. We will be blogging about things as they come up, but the future of the DPDI is clouded in uncertainty at the moment. So on that note, I will hand over to Martin, who's going to talk a little bit more about international transfers. Back to you.
Thanks, Brent. Yes, so you'll see that we swapped things around from the last update in June. So I'm going to do international transfers this time, just to keep it interesting. We seem to cover these two topics, I think, probably for about 18 months now. You'll see that progress is a little bit slow in some of these things. On that first point, so we have, I think, said in June, that the new IDTA for the UK was finalised back in February and came into effect in March. The ICO's guidance on carrying out transfer risk assessments when making international transfers was in draft at that point, and I contacted the ICO and said, well, when's this going to be finalised? And he said it's going to happen soon. We are now on the 10th of November, and that guidance is still in draft form, and we still don't have the talked about transfer risk assessment tool that the ICO has said it will produce. And I think on this, so I've seen an FOI request that someone put in to actually find out what on earth is going on with this. And the response from the ICO is, well, this is very difficult. We need to make sure we get the guidance right because people will be relying upon it. And it's going to take a lot of time to do that. And you may very well ask, well, how on earth are organizations who are supposed to be doing this supposed to carry out transfer risk assessments without any guidance from the regulator when the regulator itself says this is a very difficult issue? So it's a quite unsatisfactory situation we find ourselves in, that 6 months after the new transfer tool came into effect, we still don't have any guidance from the ICO on this. The latest we have seen on this, there was talk about it being published this month or later this year in some conference speeches we've seen. But the indication is going to be that actually that guidance will be substantially different to what was in the draft. Picking up on some of the feedback I think the organisations have encountered around how difficult transfer risk assessments are and the time and money that's spent to actually do them. So we'll need to see what actually happens with that, but it does sound like there will be considerable changes under the UK regime. I think in terms of making it easier for organisations, it's not going to become harder or more extensive or more onerous. So that I think will be welcomed by organisations. Though as Grant says, if you are dual regulated, you need to bear in mind that if you are transferring data subject to EU data protection law, then you'll need to comply with EDPB guidance on that. You can't just find what the UK is saying. So that finalised guidance, we're expecting it will have two options in it in terms of how you carry out your transfer risk assessment. One of those will be to compare the laws of the destination territory to the UK, the laws in practice there. And a second one is to do an assessment comparing the position of the data subject, looking at that particular transfer, so as both a general analysis of the laws in that destination territory, compared to what would happen if it was in the UK and what happens if it goes ahead. And remember, all of this is really about ensuring that the rights of the individual in relation to that data are maintained when you're making a transfer. So option 2 is very much a sort of, in this circumstance, what is the actual risk, as opposed to the very high level assessment. And that's going to require, as if you've done a TRA, you will be aware, this is not just about data protection law, but you're looking at things such as surveillance powers of law enforcement, human rights legislation, all that kind of stuff. There is, I think the guidance will be clearer as to the extent you have to go to on this and what sort of resources you can rely upon. So there's talk about using the FCDO, human rights and democracy reports on territories around the world, rather than perhaps needing to commission legal advice on a detailed treaty of the laws of that destination territory. We will see the detail when this comes out, but it does sound like this is moving towards making it a little bit easier for organisations. And again, I think the ICO is certainly being a lot more pragmatic in terms of it saying, well, what is a reasonable proportion investigation? You know, look at the data involved. How far do you need to go? So if you are exporting health data or financial data or something like that, then the expectation would be higher versus what you might do if, say, you just have, I don't know, email addresses for marketing purposes or something like that, where the data is fairly minimal. So we will see what comes out of this, but we are told it's moving direction, which I think picks up on some of the frustrations and difficulties that we probably all encountered in trying to go through this process. And again, in terms of TRA record, recording what you've done, you know, it kind of writing out how you approach all of this is really important, I think, in terms of being able to justify your approach. So even if someone challenges it and disagrees with you, at least if you've got your workings in the assessment you've done, it will make it much easier to show that you have thought that you're doing the right thing. But as I say, you know, this is all about the UK regime. So if you're an organisation who is also subject to EU data protection law because you are a processor for an EU controller, or because you are caught by the extraterritorial provisions of EU GDPR, then you just need to remember that you need to bear in mind what's going on in the EU as well. So on that note, if you'll be aware again from our previous sessions that the European Commission published new standard contractual clauses last year. If you are currently relying upon those and you are making EU GDPR regulated transfers, then the deadline for replacing those with the new SCCs is 27th of December. So you want to get that done before Christmas, unless you want a very busy Boxing Day. The deadline for UK transfers in terms of using the new IDTA is much further away, so that's 21 March 2024 for transfers made prior to September this year. As I say, just bear in mind which regulation you're caught by. So if you are subject to EU GDPR, then it's the new SCCs. If you are doing a transfer that's regulated by UK GDPR, it's the IDTA. And if you're doing a transfer that is covered by both GDPR and UK GDPR because you are dual regulated, then the best thing to do is to use the new SCCs and the UK addendum to bolt onto that. Just finally talk a little bit about where we are with the US. So you'll be aware again from previous sessions that Privacy Shield was struck down by the ECJ in the Schrems 2 case. So we are moving towards a new regime in that. There was discussions earlier this year that we touched upon in June between the EU and the US. Last month, President Biden signed an executive order which effectively brought into effect bits of the new US data privacy framework in terms of the legal basis for some of the controls and measures that are in there. And that has now enabled the UK government and the European Commission to commence their respective adequacy assessment procedures for approving Privacy Shield. So I'd expect the UK government probably will approve theirs first because it's a much simpler process and there's only one country involved, whereas the Commission needs to publish a draft decision, which then goes to the member states and to others for their views before it gets finalised. The UK government said it was looking to finalise it, I think, in I can't remember the exact term they used, but they implied it would be within weeks and months, whereas the Commission is more likely to be a sort of 6-7 month process. But we will keep you posted on that. And then the final thing to talk about in international transfers. So the UK government has made quite a lot around new adequacy agreements around the world. We had over the summer an agreement in principle with the Republic of Korea. So that is moving towards formal adequacy as well, if you are an organisation that's making transfers to Korea. That's all I was going to say on international transfers. So I'll hand over to Rachel and Grant, who will take you through the next section.
Thank you, Martin. So Grant will shortly speak in detail on two particular topics where we've had new guidance, but we also wanted to draw your attention to other developments from the ICO and EDPB since our last update. So firstly, published on the 27th of October and open for consultation until the 26th of January, we have new ICO draft guidance on processing information on employees' health. As a response partly to the changing world of work resulting from the impact of the pandemic, the draft guidance covers key topics such as lawful basis for processing health data, data minimisation, transparency, as well as guidance on specialist topics such as sickness, injury and absence records, occupational health schemes, medical examinations, genetic testing and health monitoring. Secondly, and as it has been doing gradually since the GDPR came into force, the ICO has published a new detailed guidance section on its website in relation to direct marketing by electronic mail and live calls. So particularly if your organisation does any electronic marketing, that guidance will be useful for you. There is a second consultation now open on the Age Appropriate Design Code, sometimes known as the Children's Code. That consultation is open until 5 p.m. tomorrow, and the ICO is seeking views on the code, which is centred around ensuring children's privacy and that is protected whilst children are online, and it applies to providers of online services to children or that can be accessed by children. There is also new ICO draft anonymisation, pseudonymisation and privacy enhancing technologies guidance. This is open for consultation until the 31st of December, and one particularly interesting aspect of this is around the interaction between the definitions of anonymisation and pseudonymisation, and the ICO in particular looks at the likelihood of being able to identify personal data and whether that's effectively anonymised or not. So the conclusions it's drawing there is that pseudonymised data which have the means and additional information to decode it, so the organisation that has that pseudonymised data, that will be classed as personal data. But if the organisation doesn't have the means to identify the information, so the key or the source to be able to match up the data to identified data subjects, then that is not personal data, as it is effectively anonymised, which is an interesting development there. And finally, on the UK side, there is now also a second public consultation on the draft journalism code of practice, which is open until the 16th of November. And also briefly looking at the EU, although for organisations that are only caught by the UK GDPR, the Information Commissioner's Office has confirmed that EU guidance does still continue to be relevant and useful at providing examples and clarification on the law. And so we have new guidelines on identifying a controller or processor leads supervisory authority in the context particularly of joint controllers. And then there's also new guidelines on data breach notification. So that's notification both to the supervisory authority and also to data subjects themselves. So we just wanted to draw them to your attention, and Grant will now go on to look at the new employee monitoring code in more detail.
Thank you, Rachel. Yes, this was something that we have been expecting for some time, and it's worth drawing to your attention. So this is a live consultation. So this is the ICO's updated or new employee monitoring guidance. Shout out to consultation. It was published in October. The consultation, as the slide says, closes in early January. Now, there was previous monitoring at work guidance that was issued, but it's a very, very old, pre-GDPR, and the world has moved on an awful lot in the time since that guidance was published. So this is long overdue. Just wanted to pick out some things that I think are worth highlighting. It is a good read. It is definitely worth looking at the guidance, particularly obviously if you're an employer, you want to know what the ICO is thinking, but there's still time to change, obviously, as a result of the outputs from the consultation. But there were a few things that were worth drawing to your attention. So first thing is just in relation to employee monitoring. Unless there is a legal obligation to conduct monitoring, the legal basis for monitoring is likely to be legitimate interest. So, the problem with consent in an employment context has always been the imbalance of power and whether employees actually have real choice in consenting when they're being asked for the data to be processed. So the ICO is saying in the guidance, you will generally be looking at legitimate interests unless there is a legal obligation. For example, as we've said on the slide here, in relation to monitoring drivers' hours. Interestingly, the guidance says that you need to be able to point to a specific legal obligation, but in terms of source, you can look at kind of official guidance or advice. So you can look at UK government advice and guidance as to whether somebody has an obligation to do something, and that would be sufficient in the ICO's mind, to justify a legal obligation justification for monitoring. But the likelihood is you'd be looking at legitimate interest, which means you're in a legitimate interest assessment situation. And what the ICO says in the guidance is, if there are ways that you can achieve the end in a less intrusive way, then you will not be able to rely on legitimate interests. Special category data, we've had over the years a lot of queries about things like biometric monitoring in relation to access systems to buildings, etc. But it also covers fingerprints, voice recognition, including also the incidental collection of special category data. For example, if your monitoring activities are sufficiently wide that it's likely that you will collect special category data even if you're not meaning to, then the ICO says that explicit consent can be appropriate, but you have to think about the balance of power, you have to think about the level of intrusion, and you have to also think about whether or not the individual actually has a choice. So the example given in relation to, for example, the use of biometrics on door entries into a building is, you can do that with explicit consent, but you have to offer your employees real choice. So if they don't want their biometrics taken in order to access a building, you have to give them an alternative, and you can't disadvantage them as a result of the choice that they make. The ICO also makes the point in the guidance that you have to think about where your monitoring data is actually going to be held, particularly with commercially off-the-shelf solutions, which you may employ. Where is that data going to be held? Because if it's going to be held outside the UK in the EEA, or in a country for which there is no adequacy decision, then the rules on international transfers will apply if the data is actually transferred to another legal entity. So if it is transferred, but it is within the same legal entity, there is not a restricted transfer. But if it isn't, so it goes from even intra-group, from, in an HR system, and the data is being transferred from a subsidiary to a US parent, then that would be a restricted transfer. So you need to think about that. And also you need to think about the privacy impact on individuals, and that's something clearly that the ICO is very hot on, and you need to record your assessment. So when you're thinking about how you are monitoring employees, then you should be thinking about a DPIA, you should be thinking about consultation with employees. The guidance reiterates a point that I think was in the original guidance, that covert monitoring is very, very rarely justifiable. So your processing needs to be fair, it needs to be transparent, and very much encouraging consultation with workers. And I suppose that the other thing that the ICO says, which I think is very helpful, is just because you may have a contract with a client and the client wants you to conduct monitoring, that's not in itself a justification for doing it. You need to consider, you need to take your own view as to whether or not monitoring is appropriate and whether or not it can be justified. And I guess that brings out the wider point that is worth just drawing out, that you have, when you're considering the guidance, you've got to think about your wider duties as well. So it's not just a siloed exercise. You need to think about DPIAs, you need to think about your legitimate interest assessments, your ROPAs, and transparency, how you're going about doing your monitoring. So a lot of good stuff in there, definitely worth the read, and the consultation is open. So if you have views on it, then do actually respond. Moving on, I wanted to talk just a little bit about cyber, so slightly wider than just data protection. So we're talking here about consultation on proposed changes to the Network and Information Systems Regulations 2018. Now, these originated back in the days when we were within the EU from a cybersecurity directive that came into force in 2018. So the NICE regulations apply to two categories of organisation: operators of essential services, so those providing specific activities in key sectors such as transport, health, utilities, digital infrastructure, those sorts of things. And also the second category is relevant digital service providers, so anyone providing digital services, so things like online search engines, cloud service providers. So these are the kind of two categories of organisation that are currently caught by the NICE regulations. And the NICE regulations require them basically to do two things. Firstly, to maintain security measures to protect the systems, to avoid failure, and secondly, to report incidents that affect the continuity of the services provided. So that's the kind of basic backdrop. The consultation is proposing a number of changes to the regime. And in part, this is about widening the regime to trickle down into service providers. So the first thing to note is the proposal is to expand the scope of digital services to include managed service providers, i.e. those that provide services to those that are already regulated. And that's so that really is expanding the categories of relevant digital service providers to include managed service providers. The proposals involve a new two-tier supervisory regime. for all relevant digital service providers. So proactive supervision from the ICO for those that are most critical, while the continuation of the more reactive supervision for everyone else. Government wants to take delegated powers to enable it to update the NICE regulations without an act of parliament. The way things are written at the moment, it needs to come back and get an act of parliament, which it thinks is slow and unwieldy. So it's seeking the powers to adjust the regime by regulation, both in terms of framework, but also in terms of scope, subject to appropriate safeguards. It is also looking to create a new power to bring organisations, i.e. ones that those that are already in scope are critically dependent on within the remit of the NICE regulations. And it also wants to strengthen the existing incident reporting duties, in part because there are not actually that many reports being filed. And that's because I think the reporting obligations at the moment really are about actual incidents that have affect continuity of service. What the regime will be extended to is to include incidents that would have affected continuity of service. So there are more reports that are actually will be passed up to regulators so they get a clearer idea of actually what is going on out there. And then I guess as that regulatory remit becomes greater, no surprise, the government's looking for the ability to move the burden of regulating the regime from taxpayers to those that are actually regulated. So the government's looking to extend existing cost recovery provisions to allow the regulators to recover reasonable costs for their implementation and supervising the companies that they regulate. So we can see, and there is a parallel exercise going on, as I mentioned right at the top of this. This regime started off life as an implementation of an EU regime. The EU is also looking at revising its regime, and I think what's interesting is the UK's consultation is going in a different direction to the EU one. So the EU one is looking actually at doing much more extensive listing of sectors that are actually going to be caught by these regulations than the UK is currently proposing. So UK is proposing some extensions, but the EU regime is proposing to move into sectors such as food. So that's a good example of something where the UK just isn't going at the moment. And the UK had a narrower list anyway, because actually a number of sectors were excluded from these regulations on the basis they were regulated by others, including, for example, the financial sector regulation. So we're seeing a divergence between the UK's approach and the EU's approach. Last thing I just wanted to flag just briefly, there is new guidance, very useful guidance, I think, issued by the National Cyber and Security Centre, the NCSC, on supply chain security, and it's very, very useful. It's got a 5-step process for assessing risk in supply chain, and I'm not going to go into the detail here. It's very practically written, but it is definitely worth, if you're not aware of it, going and having a look at what is being said there, because supply chain, I think, is underestimated as an area of risk for many organizations. So putting in place the measures that are being suggested, or certainly looking at them, being aware of them, I think is a definite recommendation. So that's all I wanted to say on that. So back to Rachel, who's going to talk a little bit more about latest developments in enforcement. Thanks, Rachel.
Thanks, Grant. So yes, I'm just going to run through some recent ICO decisions and some learning points that we can take from each of them. So firstly, Interserve, following an investigation, the outsourcing and construction firm has been issued with a fine of 4.4 million. Basically what happened was an employee received a phishing email, but then forwarded it on to another employee who then opened it and downloaded its content. This resulted in the installation of malware into the employee's workstation, and through this, hackers compromised 283 systems and 16 accounts, leading them to access personal information of up to 113,000 employees. And the data that they got access to was both personal data and special category data. And the hacker encrypted and rendered that personal data unavailable at that point. In issuing such a big fine, the ICO was primarily very concerned that there were no appropriate security measures in place to prevent such an attack, or which then left them vulnerable to an attack. For example, some of its systems and protocols were outdated. It was using unsupported Microsoft operating systems. It had out-of-date antivirus software, and it didn't provide any evidence to the ICO when requested of any penetration testing in the last 2 years prior to the incident. And the ICO also found that there was a lack of staff training on data protection. So the employee that opened the email, I don't think they had done any training, and they had also not conducted any risk assessments. So all of those factors together resulted in that fine of 4.4 million there to Interserve. On Easy Life, this is a really interesting case where the ICO levied a fine of 1.3 million for various breaches of GDPR and PECR. In short, Easy Life is a household products business. It sells predominantly through catalogues, and what it did was it made up a list of 122 trigger products. If an individual then purchased one of these trigger products, a marketing call was then instigated, linking or trying to sell that individual something that it thought that individual would then be interested in. So, for example, if someone purchased something like a product that would help with mobility, they were then phoning that person up and asking them whether they would like some glucosamine, because they inferred through the purchase of the trigger product that individual had arthritis. The main concerns that the ICO had here was around using data about purchase transactions to make those inferences about health conditions, and then it said that that constitutes profiling, and that profiling then generated special category data, and as part of issuing that fine, the ICO said that individuals weren't adequately informed that this was happening, so there was deficiencies with its privacy notice information, and also it had no legal basis to process that resulting special category information, and the ICO said in that case the most appropriate basis would have been explicit consent. On subject access requests, 7 organisations recently have been issued with reprimands for failing to comply with the rules around data subject access requests. These organisations cover the private and public sector, so Virgin Media, along with the Home Office, Ministry of Defence, and 3 different London borough councils. All of the cases involved issues with the time taken to substantively respond to DSARs, and those 7 organisations have all now been given a period of time in which to demonstrate that their processes have now improved. At that stage, if they can't then demonstrate that, a fine will likely then be levied on them. So in particular, in the MOD case, they were found to have a backlog of 9,000 DSARs, with people waiting on average 12 months for a response. And in relation to Virgin Media, the ICO found that only 14% of the 9,500 DSARs it received over a 6-month period had actually been responded to properly. Moving on to TikTok, and notice of intent to fine TikTok of £27 million has been issued for various breaches or purported breaches of the GDPR and Data Protection Act 98 relating to processing personal data relating to children without parental consent and failing to provide proper transparency information to individuals. So again, that links to the Easy Life case there, and around how important privacy notices are when you are processing personal data. The PECR breaches continue to mount up. These are fairly regular for the ICO, and most recently they have issued fines on companies including Halfords, GreenLogic UK, Posh Windows UK and Euroseal Windows. In Halford's case, there was a dispute around whether an email was marketing or service email, and the ICO disagreed with the categorisation of a particular email, which was drawing to individuals' attention a government scheme to fix your bike was not in fact a service email, but it was marketing, because ultimately Halfords would have benefited commercially from an individual going to Halfords under the scheme rather than another retailer. And the other companies there were fined between £40,000 and £150,000 for various PECR breaches, including not keeping records of individuals who then wanted to opt out of live marketing calls, not being able to evidence rights to conduct direct marketing on specific groups of individuals, and not being transparent with individuals when making live calls, which is a particular requirement there in that circumstances. And then finally, what's quite interesting is the fine that was initially issued on the Cabinet Office of £500,000 as a result of the New Year's honours list information being breached. So essentially, the individuals who were going to be in receipt of New Year's honours in 2020 was posted online for about 2.5 hours. That fine has now been reduced to £50,000, which is quite interesting. The ICO in that case has said that although they consider the original fine to be proportionate, so the £500,000, they recognise the current economic pressures that public bodies in particular are facing, and that fines may be less critical in achieving deterrence. So that could be a sign of things to come, whereby the ICO seeks to look at other ways of enforcing compliance rather than just the threat of fines, no matter how big that they are. And finally, in terms of some horizon scanning, what should we be looking out for? So we've discussed earlier on in the presentation where we are with the new Data Protection and Digital Information Bill. So I think we just have to wait and see what happens there. I don't think we're any further forward with knowing exactly what the approach that the current government is going to take on that. We do hope that we will finally get the transfer risk assessment tool and guidance issued at some point. And also you may have or may be aware that we have been waiting for a while for some finalised.
And we have UK GDPR, we have the 2018 Act. So we've got two bits of legislation at the moment sitting on that. And then the way that the DPDI is drafted is it's very, firstly, it's very lengthy. There's over 100 clauses, over 13 schedules. And a lot of it is cut and paste stuff. So changing this, making changes here and there and everywhere. And actually, I have a real concern that if you put all of it together, then for us, it's a challenge to understand it. But for folks who aren't lawyers, actually pulling this all together is actually really difficult. And, I'm speculating a little bit in terms of what may happen to the DPDI going forward. But, if, for example, we're going to get more and more exemptions, we're going to start getting possibly categories of organisations exempted from various bits, there's a danger that in actually trying to reduce the burden and simplify compliance, what we're going to end up with is a regime that's even more complex. Because again, it's just layering more and more stuff on. It would be good if, as part of this overall exercise, there was some consideration as to whether or not the various bits of legislation could be consolidated, whether we need a UK GDPR sitting alongside UK domestic legislation, whether or not there is some way that it can all be built into one single text so we actually can actually read it. I think there's a lot to be said for that. Having said that, clearly that government and the regulators have lots on their plate, so I'm not optimistic that they will take the opportunity, but I would certainly like to see them think about it.
Thanks. Rachel, I think there's probably one for you. You talked a bit about DSARs and the enforcement action around the delays with various organisations responding to DSARs. What are we seeing in terms of current trends around whether you can ask individuals to try to narrow the scope of their requests? Are we seeing people doing that to kind of reduce the burden a bit? What are we seeing for trends around that?
Definitely in practice, what we're seeing in the first instance is a lot of the time, particularly in the case of employees making DSARs, that they will just ask for everything, and obviously for most organisations that just causes an administrative a hurdle, particularly to try and filter through everything that they have and respond to an employee, whereas in practice and in reality, there is actually, particular things that the individual is looking for. And what we find is that, I suppose, being as open and communicating well with individuals, and starting that conversation around wanting to help individuals find what they are looking for, means that they are often quite accepting of that type of conversation and will then help narrow the scope of their request. I think it's still a little bit uncertain the extent to which employee or employers in particular or controllers can demand that someone narrows the scope of their request, but often there is usually something that someone's looking for, and if they start off that conversation, requesters are usually quite open to narrowing the scope to what they're looking for. It often works in their favour because it means that the controller can then respond more quickly as well. So there's definitely mutual benefits as well that can be communicated.
Thank you. And then just one final question. I'm conscious we're a couple of minutes over, but we've had a question which I think probably falls to me, given I did international this time, around whether we think that Privacy Shield Mark II or the US Data Privacy Framework will survive Max Schrems, and how realistic is it for business to send data given the continued uncertainty? I mean, I think on that, certainly in the UK, I think the position will be slightly different versus the EU, and I would anticipate that if and when there is a challenge from Mr. Schrems, then it probably will focus on the EU first of all, and then I think we'll see what happens to that. But until we actually see the EU Commission's draft adequacy decision to see how they justify the privacy framework as resolving the issues in the Privacy Shield case, it's difficult to know how it may be attacked. But I think it's notable that within hours of the announcement about executive order being passed, Max Schrems had already tweeted out a list of criticisms of the proposed framework. So clearly, they are looking for that, looking for weaknesses in it. As to the uncertainty, well, people are still making US data transfers. Yes, you're going to do your TRAs, but even if there is a challenge, that challenge will take some while to actually work its way from the relevant national courts up through to the ECJ before you actually get a decision on this. So I guess once we get that approval, there is probably a period of time where you've got some certainty, but certainly in the long term, it is difficult to know where this might go. Okay, so that's us. I say we're a couple of minutes over. Thank you very much for joining today. I hope you found the session useful in the future. And on that note, all it remains to say, I think from me, is thanks for coming, and look forward to seeing you again in the spring. Cheers.
Thank you.
Thank you.